Verifiable consent is one of the challenges in the implementation of DPDPA 2023. Currently, we are having a draft rules which has become available from the government sources, which give us an indication of what the government is thinking about. At the same time, there are newspaper reports stating that some of the MNCs to whom the draft rules were presented for some kind of a feedback have suggested that there is a problem in accepting the government's suggestions on verifiable consent. And the objections are basically coming from organizations like Meta, which manages the Facebook, and perhaps even Google also. This particular presentation tries to address this issue of verifiable consent as required under the DPDPA 2023. Now, if we look at the Act, Section 9 states that before processing any personal data of a child or a person with disability, there is a need to obtain verifiable consent of the parent or the lawful guardian. This particular section combines two instances, one that of a minor, another that of a person with some kind of a mental disability for whom a lawful guardian has been appointed. We know that even for the minor, who is referred to as child here, lawful guardians may be appointed in case both the parents are not alive or for some reason they are not considered capable of taking care of the minor. So legal guardian can be there for a person who is mentally disabled. It can also be there in certain cases in the case of a person who is a child, which in India means a person below the age of 18. India also has a rule that if a legal guardian has been appointed for a minor before he attains 18 years, then he will attain the age of majority only at the age of 21 and not at the age of 18. So a person who is above 18 years and below 21 years who has been assigned a legal guardian before he became 18 will attain majority only after 21 years, and he cannot be considered an adult at 19 or 20 years. Now, in such cases, Section 9 says there is a need to obtain verifiable consent of the parent. Now, when we say parent, parent also basically is a natural guardian, and father was always considered as the first natural guardian. And only when father is not alive, mother becomes the natural guardian. Now, in cases where mother would like to act as a guardian of a minor, generally it is considered that it is necessary to obtain the consent of the father. But the society has been changing. Today we have situations where there is a single parent, and women also needs to be recognized as people capable of being guardians. So there are certain gray areas where the law may say that father is the only natural guardian and he may be alive, but the mother may claim that she wants to be the guardian of the minor. These cases are considered as some let us say, complicated situations where a data fiduciary needs to exercise caution. If he senses that there is a dispute between the two parents, and there is a likelihood of the father perhaps raising an objection for the mother to be accepted as a guardian. Now, the data fiduciary has to take a risk in accepting the mother as the guardian. So therefore, if there is a need for a data fiduciary to decide that they have to take a consent from a guardian, there has to be a process whereby if the person is not a father, then there has to be some kind of a verification whether the father is agreeable for the mother to be a natural guardian. There is also a question of what this verifiable word means. What is that we need to verify? Is it that we are verifying whether the consent is given by a person who is verified as the father or verified as the guardian, or that whoever comes over as the parent, you obtain a consent and that consent is verifiable in the sense that you can check whether the person has really given a consent or not. Of course, all consents are to be considered as verifiable because a consent has to be like a contract. So you give a notice and then get a consent, and the consent has to be available for future reference. The onus of producing the consent will be with the data fiduciary. So every consent is a verifiable consent. So what is the speciality of calling this particular consent as a verifiable consent unless this verifiability is to the factor of whether a person is a parent or not, whether a person is a lawful guardian or not. So verifiability refers to the fact whether a person is a parent or a guardian. So if this is not done, this is not proper verification. The other aspect of verification is whether this person is the person for whom the consent is being given is actually a minor, and even only when he is a minor, you actually seek the details of the guardian and obtain the consent of the guardian. What if I don't know that a person is a minor? I don't take the responsibility for checking whether a person is a minor or not. Then I will never ask the question of who is your guardian. So this verifiability can be a term which can first be applied to whether the person who is providing the consent is a major or not, is competent to enter into a contract or not. And then if he is not competent to enter into a contract because of age or mental disability, who is the guardian? And then approach the guardian, verify that he is the person who is supposed to be the guardian, and then take his consent. So these are the different dimensions of this verifiability of the consent. Now, if we look at the draft rules which has been in circulation presently, this is actually a draft of the draft rules. We are expecting perhaps one more modified rules. And in this particular draft, there is a rule 10 which says a data fiduciary, while obtaining verifiable consent from an individual who is identifying himself or herself as the parent of the child, for the processing of personal data of such child, shall observe due diligence to confirm such individual is not a child, and secondly, to reliably identify that such individual providing the consent in case her identification is required in the interest of prevention, detection, investigation of prosecution of any offense or contravention for the time being in force in India. What does this complicated rule mean? Is it not necessary to identify the person claiming to be the guardian or parent if it is not a situation of a suspected crime or something like that? And what do we mean by due diligence? Due diligence is normally a broad word which can be interpreted. And what we are doing today perhaps is trying to look at the definition of due diligence in this context. So what these rules suggest is that the parental consent should be obtained in a manner after exercising due diligence. Now, because this DPDPA uses the terminology her instead of him in most of the cases, here also it says that while obtaining verifiable consent from an individual identifying herself as the parent of a child, this does not automatically override the law of, let us say, the father being the preferred natural guardian. Though we never know, the courts may start ruling that that particular concept is no longer valid. But by using the word herself here, we are actually trying to make people think that the mother also can be a parent in the case of a child. And though this is open to further, say, debate, it is something which we have to live with because of the nature of drafting of DPDPA. Okay, we will for the time being consider that that is a minor issue. But this identification of an individual obviously cannot be only in the case where there is an interest of prevention and detection of crime, etc. It has to be in every other case also. So we do not know why such a clause was introduced in this particular Rule 10. Now, this rule talks about the method of obtaining the consent. It says by reference to reliable details of identity and age available with the data fiduciary or collected by, it uses the word her, but actually by the data fiduciary with the consent of such individual. So the identity and age has to be collected from such individual. Here, such individual essentially means the guardian, but a person is named as a guardian only after the minor who is seeking the service declares that he is a minor and therefore so and so is my guardian, which means that the identity of the guardian itself is identified or confirmed by the minor. So there is a flaw in the system where the minor suggests that so and so is my parent, unless you actually verify from the parent who is his minor ward and does he have a ward by the name and identity of the person to whom the particular service is being sought to be given. So this issue remains. The verifiable consent can also be obtained by the use of a token in electronic form mapped to the identity and age details of, again, such individual. Now, such individual again, whether it relates to the parent or to the minor is little unclear. And voluntarily provided by her, which has been generated by an entity entrusted or permitted by law or by central government for maintenance of identity and age of individuals. Now, which are the agencies which the government of India has permitted to maintain the identity and age of individuals? One, of course, is the Aadhaar authority, maybe the PAN income tax authorities, and such other institutions, which means that the rules is suggesting that an entity entrusted or permitted by central government to maintain the identity and age of individuals alone can act as an organization which verifies the fact that the age of a person is so and so, or the person name is so and so. See, it appears that while framing these rules, only the need to verify that the consent giver is not a minor is being addressed, but it does not address a situation where the consent seeker, that is the minor, whether that person himself is verified as really a minor or not. We can assume that if he is not a minor, he will not seek or suggest somebody as a guardian. But still, that clarity is absent. Now, the rules also state that apart from the entity itself providing such a consent, under the permission given by the government, any person who is appointed or authorized by such entity also can provide such consent. This essentially means that the Aadhaar authority, UIDAI, can give the consent, or any of the authorized user agencies of Aadhaar can also give such consents. There is also a mention that digital locker service provider can provide a verifiable consent. See, today digital locker is a repository of documents, and the digital locker service provider does not verify the documents, he just holds the custody of the documents. So probably a person has put in a birth certificate or say the Aadhaar in his digital locker account, DigiLocker account. And when required, the depositor is the person who can authorize that the particular document can be presented on request by another organization. So therefore, if the data fiduciary requires to know the age of a person, that person can only give a reference to the Aadhaar card which is there in the DigiLocker. But as of now, DigiLocker does not open the Aadhaar card and see what is the date of birth and confirm whether the age of a person is above 18, below 18, or whatever is that. So this particular clause of the rules is also unclear. What it essentially means is that the rules have not been properly drafted as far as this is concerned. Now, as regards the disabled person, the rules say that a data fiduciary, while obtaining the verifiable consent of a person identifying himself or herself as the lawful guardian, is also in fact certifying that the other person is actually mentally disabled. Now, or he has got an effective court order. So the lawful guardian, if you say this appointment has to be verified, it has to be verified with reference to a court document. And he is also supposed to exercise, the data fiduciary in this case has to observe due diligence, which includes the current validity of this certificate issued by a court, and whether it applies to the particular context. So due diligence in respect of the mentally disabled person includes the verification of a court document, whereas in the case of a minor for whom no legal guardian has been appointed, the due diligence is related to the age verification. In both cases, the person who is claiming to be the guardian has to be verified as to his identity. It is presumed that that person is not a minor. So when you check the identity, you also identify that he is not a minor. So double verification is required as far as the guardian is concerned. One, what is his authority as a guardian? Secondly, that he is having that relationship with the erstwhile minor as a father or mother or a court-appointed guardian. So these are the things which has to be taken note of in terms of the rules. Now, most of the time, we just take a declaration, I am 18 years and above or something like that. Or in some cases, we try to cleverly draft the terms and conditions or privacy policy in such a manner that a person says, I am legally competent to enter into a contract. This takes care of the situation where different countries have got different age criteria for determining the minor and the major, and also takes into account this 18 years and 21 years, which arises in India for minors for whom legal guardians are appointed. So either way, this is a declaration by the person who is seeking a service which he would not get if he is a minor. So he has to say that I am not eligible for this service because I am a minor. So I will suggest so and so as my legal guardian or the natural guardian who will give the consent on my behalf. Now, if he gives a false statement and just does not declare that he is a minor, then the data fiduciary has no means of verifying. Though there was one case in which Facebook was once challenged that they had not taken the consent as a minor, and the person had posted subsequently information on the Facebook account about a birthday celebration, which declared that the person was celebrating a 13th year birthday or something like that. So the content gave away information that the account holder was a minor, but the person had not declared that he was a minor. In the age of artificial intelligence, perhaps this may be possible, but still it can only happen subsequently, provided the content is actually indicative of the age of a person. So this problem of a minor declaring himself as a major will arise in cases where a person seeks access to, say, adult content, or would use a credit card of his parent or somebody to do e-commerce purchases. Because when the dispute arises, the e-commerce entity may not have sufficient recourse to the minor, and perhaps even his parent may actually refuse liability because he is not directly a party to the transaction. Now, the whole system which allows a person who may be a minor to declare that he is not a minor is faulty. So the only way we can correct this is to ensure that age verification is made for every consent. That is, every consent taken by a data fiduciary should ask the question, what is your age? Okay. And it has to be verified. The verification has to be that the person is above the age of 18. Okay. Or above that age where he is competent to enter into a contract. So the declaration has to be like that. And if you say verifiable consent, then verification is applicable for every consent, and age verification has to be there for every consent. This is why we say age gating is an essential aspect of the content. Worldwide, there are some methods which are being used. For example, sometimes people use email or mobile as a verification, where the minor declares that so and so is my father, his email address is so and so, or mobile number is so and so. Then the data fiduciary can send a message there, and through OTP or some other form can obtain the consent of that particular parent. This is one of the straightforward methods. Long time back, people used to use the credit card verification method of charging 1 rupee or something like that, a nominal amount, assuming that if a person is able to give a credit card, even for authorization of 1 rupee, it means that he's a credit card holder, and nobody will be issued a credit card unless he's of 18 years of age. So under that presumption, credit card verification was available. There is also a view today that we can use a video call or a telephonic verification. If you use a video call, perhaps you can look at the picture of the particular person and then perhaps try to get the view of whether a person is a minor or not. Other than this, of course, the government issued ID verification is one of the aspects, or a third-party verification service can be used. In India, of course, both this government issued verification and the third-party verification are feasible. And today people are talking of AI-based methods where using a picture, one can estimate the age of the particular person, and this also has to be considered a method which requires more validation in due course. But otherwise, India has the option of using the Aadhaar card, which is a government issued ID. We can use virtual Aadhaar identity and then verify the age. And in India, when an Aadhaar card is issued for a minor, that also mentions who is the parent. Therefore, the requirement of identifying who is the natural guardian, etc., is actually carried out by the Aadhaar card itself. PAN card also can be used for people who have the PAN card. Here also there is a government entity which can use, and also there are agencies like chartered accountants who are allowed to look at the PAN card data, so they can also act as the age verifying intermediaries. SIM cards in India again are issued only for adults, and TRAI has been collecting Aadhaar data for SIM card, and they have even offered that the name of the SIM card holder can even be displayed in the incoming calls, and maybe similar system can be used by TRAI to be the agency which confirms the name of the that a person is an adult. Driving license is another document which carries the age, which also can be perhaps used so that the RTOs can become the confirming agencies. Banks also can be confirming agencies. So these are the multiple options which are available in India, out of which, of course, Aadhaar seems to be the best option, particularly when we use virtual Aadhaar and we use the yes or no response to check the age, like are you above 18 years of age or not? Yes or no. Is this person's parent? If no, okay. Is this person's parent name is XYZ? Yes or no. Something like that can be used under the Aadhaar, which is the best method as of today in India for verification of the age and who is the guardian of a particular person. When legal guardians are authorized by courts, courts can also ask for immediate change in the Aadhaar card of the erstwhile the disabled person, and direct that the Aadhaar has to be modified, showing the legal guardian's name there, in which case a similar system using Aadhaar will be sufficient. And in fact, FDPPI Innovation Center is working on a solution which will shortly be available. Now, as I said, SIM card, if TRA is willing, perhaps can provide the basis for verification, PAN card. But one thing is that the verification has to be for all persons. But when it comes to the disabled person, courts do not have a system of identifying or publishing when they have issued the legal guardianship certificates. Perhaps that system needs to be introduced. But one thing we have to remember is in the case of these minors, it is not only that there is a need for some kind of verification activity at the time of identifying the minority and giving registering a person for the service, but also when he attains majority, you need to actually switch over the control of the account to the erstwhile minor. So which means that 18 years from the date of birth, the parent ceases to have authority to operate the account on behalf of the minor, and therefore the control has to be passed on to the minor. Now, for that, you have to take the consent of the minor. But that consent can be taken only after the minor ceases to be a minor. You cannot take it even one day in advance, because one day before 18 years, he is still a minor, so he cannot give a consent as a major. So therefore, you have to wait until the person attains majority and then request him, give him the appropriate notice, request him to consent, and then record the consent. So there is a small time gap in which there will be an expiry of the previous consent and there is no renewal of the consent. Now, during that time, the processing may have to be discontinued and there has to be a break. Again, when we identify a particular date when a person attains majority, normally we go by the date, assuming that at 00 hours on that particular day, the person has become a major. But we do not know, at some point of time in future, a question may come that if a person is born, say, in the evening at 1800 hours, how can he be considered a major, say 18 hours before he becomes a major? So therefore, unless you know the time of birth also, you will not be able to exactly identify the time and the date after which he attains the age of 18. So this particular issue remains. And we are suggesting that you give a gap of at least 24 hours, which is to be used for obtaining the consent of the erstwhile minor. And within that 24 hours, perhaps this issue of time will get resolved. So breakage and discontinuance of 24 hours in the processing of the minor's data is to be considered as natural, and that has to be accommodated. In the case of the disabled person, the court is the one which appoints the legal guardian. At present, there are no database of such appointments, and sometimes perhaps it may even be revoked if somebody applies to the court that this legal guardian is not capable of taking care of the minor, and the court may consider the facts and perhaps appoint some better person. So looking ahead, we feel that the FDPPA system of having the 24 hours break should be part of the rules, and the courts should publish a register of legal guardians, and age verification has to be made for every consent and not for only those who declare themselves as minors. These are the three major requirements which the rules should cover. At present, it has not covered, and we have already brought this to the notice of the ministry. We have also written to the Chief Justice of India to introduce a system of legal guardian register to be maintained. And we hope in the next set of rules, the government will introduce a more clear rules on verifiable identity. Thank you.